Hello, this is Rich Grungo from Grungo Colarulo, and we're here to talk a little bit about the arbitration process. The video you're going to see is going to provide you some basic information about what to expect when you're told your arbitration has been scheduled.
For purposes of the arbitration, you should dress in a suit if you have one available to you. Otherwise, business casual is perfectly acceptable.
What an arbitration is kind of a mini trial in of itself. It'll be down at the courthouse. There's arbitrators there that are appointed by the court. Depending on the county that your case is venued will depend on how many arbitrators there are. What will happen is you'll go down to the courthouse with your attorney. The attorney is going to hand the arbitrator or arbitrators a packet that's going to summarize your case, what happened, what your medical treatment was, what your injuries are, and how this has impacted your life. The attorneys, both your attorney and the attorney for the insurance company, will be called into the room with the arbitrators to give a brief opening statement while you wait outside the room. After that opening statement is given by both parties, the attorney will come out to get you to come in to testify. It's not going to be anywhere near as long as what your deposition was. You most likely will only testify for 5 or 10 minutes. A lot of times the arbitrator only wants to know a very little bit about how you were doing before the accident, what the accident was, and then how you're doing now.
Every arbitration is handled a little bit different depending on the personalities of the arbitrators. Sometimes the arbitrators don't even want to take testimony. They're going to rely on the documents submitted or the paperwork. Sometimes the arbitrators take extensive testimony and ask extensive questions. But very similar to the deposition that you gave, the most important part of an arbitration is for you to tell the truth and for you to leave that room knowing that the arbitrators, the defense attorneys, and anybody else who was in that room found you to be credible and straightforward regarding what happened to you and your injuries.
Different than your deposition, at an arbitration, it's going to be your attorney, us, asking you the questions. When we've finished, the defense attorney will have the opportunity to cross-examine you. They may or may not do this. If they do cross-examine you, the questions that they're going to ask you are most likely going to be leading questions. A leading question usually only requires a yes or no. And you'll see that because they're doing leading questions, they may be a little bit more aggressive with you. It's important not to get too flustered, not to get too angry, and be yourself and answer the questions that are being presented to you.
Prior to the arbitration, you should review your deposition transcript to go over your deposition testimony and refresh your memory as to what you may have said months ago at the deposition. During the arbitration process, you might be confronted with testimony that you gave during the deposition in one way, shape, or form. If you are confronted with deposition testimony that you gave several months ago, you may or may not recall what you said at the deposition, even despite reviewing your transcript. Just be truthful at the arbitration, and the arbitrators will get a good impression of you as a person and the plaintiff in the case.
Those arbitrators are going to deliberate, just like a jury would. They're then going to call us back into the room, and they're going to tell you what they think a jury in that particular county would do with your case. They're going to have to answer a couple of questions. One, who was at fault for the accident? And then depending on the law that applies to your case, whether or not you satisfy certain injury thresholds. And then the final question they'll have to answer is how much money do they think a jury would award you in that particular county for your case? This is the opportunity for a neutral party, one arbitrator or two arbitrators, depending on the county we're in, to give a number that they think the case is worth. So hopefully, if we're able to get a strong number, that can help us in our negotiations with the insurance company.
An arbitration is not a binding process. If either party is unhappy with the award that's rendered at the time of the arbitration, either party can file what's called a trial de novo and appeal the arbitration award.
We have 30 days from when we receive the arbitration award to make the decision as to whether or not you will be rejecting or accepting the award, being mindful that just because you may want to accept the award does not mean that the defense attorney will. If either party rejects the award, then we will receive a trial date. The arbitrator's award is simply their opinion. That doesn't mean that a jury would have the same findings as those arbitrators. The bottom line is it's important to remember that an arbitration is one additional step in the litigation process to get us closer to either a trial with a verdict or a resolution. Thank you for taking the time to watch this video and learn about the arbitration process. If you have any questions or concerns, please do not hesitate to give us a call.